It's been some time since Karen Reed was acquitted of all major charges against her, but the issues are still swirling, including but not limited. Does the Commonwealth not want to give her Lexus or her phones back? Joining me today to help me is Yoli. So we all thought that since Karen Reed was acquitted, we could all go on with our lives, including her, and just walk away from it. Oh no. Oh no. Multiple documents filed this week that we're recording this episode. I'm Andrew Myers. This is About the Law, and we welcome once again Yolie Medina. How are you, Yoli?
I'm fine, thank you. How are you?
Not bad, not bad. A little bit of a heat wave here on the East Coast is over, thankfully. But we have a whole nother month of summer, so who knows?
Yeah.
The thing about the Karen Reed case is, as I said before, she was acquitted of second degree and the other major charges against her. And we all thought, well, that's it. Nuh-uh. The top issue right now, in addition to the fact that Hank Brennan has filed a motion to get himself out of the case, which was expected, and Victoria George is getting out of the case, is that the Commonwealth was playing, we're not picking up the phone on the defense's request to get her Lexus back and to obtain her phones. And I don't know what you think about that, Yoli. Let's take a look at the actual motion that was filed by the defense. This is a motion for an order to return property. Now comes Ms. Reed in the above entitled matter and respectfully moves, pursuant to Superior Court Rule 61, that this honorable court order the return of all of Ms. Reed's personal property, including but not limited to the following: the 2021 Lexus LX 570, in the personal cell phone. There were also two other phones that in a separate motion they're looking for. Listen to this. As reason, therefore, counsel attempted to negotiate the return of the listed property with ADA Adam Lally in late June. Remember, the acquittal was June 18th. So after that, late June, the defense contacts ADA Adam Lally as property is in the possession, custody, and control of the Massachusetts State Police, and has not heard back. Thus, counsel is respectfully requesting this honorable court order the return of the aforementioned items immediately. So, Yoli, what's your thought about the fact that apparently they did reach out to Mr. Lally and they haven't heard back from him?
I just think that's incredibly rude. And possibly violating some kind of law. I mean, they don't need her property anymore, so why do they have it? They should have returned it without them even having to ask.
And lawyers, by the ethical rules, are required to communicate, not only with their clients, but with opposing counsel. Yeah. If you get a phone call, now we're all busy. Lally was testifying in court the week before this happened. But I mean, the Norfolk County District Attorney's Office has a ton of employees, legal assistants, paralegals, interns, I don't know what all. I've never been in the building, but I know that they have a lot of employees. So, I mean, if the defense called and said, hey, we want her stuff back, this is an informal request, don't you? I'm not going to ask, don't you think? He should have returned the phone call. He should have had somebody, look, I'm testifying in the King case right now. I can't get back to you, but let me get off the stand and I'll call you back, or something to those effects. So that was just inexcusable, really, to me.
Yeah. He shouldn't even have to ask for her stuff back. I mean, they should just return it.
Yeah. Yeah. So my first thought was, how rude to not return a phone call at the very least, because the courts want us to have, if you go into court on a motion and you haven't talked to opposing, you might be at loggerheads. You might have bile against the person. You might just really dislike them, but we are expected to communicate with opposing counsel. So you don't go into court on a motion unless you've talked. The court doesn't want to sit there and play, kindergarten teacher between people that are, pointing fingers at each other. They want us to be professional and deal with it. And so that was my first thought. My second thought was, okay, there's two things that could potentially be the scenario here. Evidence that is actually been entered into evidence in a case is one thing, and things that haven't been entered into evidence are another thing. So things that are in evidence in a case, I can see them being held until there's either an order or appeal periods have ended. There's not going to be any appeal in this case, but so theoretically, I can imagine that they would want to at least get a court order. But I mean, they should at least talk about that, because the Lexus was never entered in evidence. There were photographs of it. They extracted things from the entertainment system and the other data in the car. Same with the phones. The phones themselves were never entered into evidence. The extractions were. They extracted the texts and everything else, but the phones themselves. So it is simply asking for her stuff back. So I'm reading this. Going to the bottom, respectfully submitted by her attorney, Stephen Bozang. What? Wait, huh?
Who's that?
Yeah, that's what I said, but there's Stephen Bozang.
Did he appear?
Yes, he has.
Oh.
He's new, 450 Washington Street in Dedham, Mass. And Stephen Bozang is a very well-known Boston defense attorney. He was the defense attorney for Cadillac Frank Salemi in the trial of the 1993 slaying of nightclub owner Stephen DeSaro. So that was a Flemmy, or I should say Cadillac Frank Salemi was one of Whitey Bulger's associates. He did a lot of Whitey's dirty work, and people that followed the Whitey case recognize Cadillac Frank. Anyhow, so I started looking a little bit deeper into him, and I found that there was a really good TV report on this very subject, and it was by Ted Daniel at Boston 25. Now, that's a reporter that's been following the Karen Read case. He did deep dives into it, and he gave us some insight into this issue.
I'm investigative reporter Ted Daniel. 3 phones and a Lexus valued at about $60,000. State police took those items from Karen Read. Now that her criminal case is done, she wants them back.
Yeah, and so this is the attorney. He does the interview in his car, and like I say, he's a very well-known Boston area criminal defense attorney. But this is new. He's stepped into this case.
I put a call in to the Norfolk DA's office and inquired about getting back the personal cell phone as well as the car. When I didn't hear back after a month, it was time to, have to file a motion and let a judge order the items to be returned.
Can you imagine that, getting a call from another attorney and not returning it for a month?
I would have been more persistent. I mean, I would have made a number of calls, but still, it doesn't matter. I mean, he made a call. He should have been returned.
Yeah, Lally's been kind of busy, but again, he's got a staff. And again, a month. I mean, I'm bad at returning phone calls. I'll be the first person to admit it. But at the end of the week, I go through them all and say, all right, it's time to get them back. But a month, that's crazy.
That's Steve Bozang. The Dedham-based attorney recently joined Reed's legal team. On Monday, Boston 25 reported that Bozang filed a motion or legal request to get Reed's Lexus SUV and 1 phone returned. We've since learned of a second request Bozang filed to get 2 additional phones belonging to Reed. State police took those in January 2024.
And that's when, in January 2024, that's when the Norfolk County District Attorney's Office went on their failed mission to get a indictment of Karen and Turtle Boy, who you see there talking to each other, trying to claim that they were in collusion, and the grand jury never returned an indictment, never was able to do anything. So that was a failed attempt on the part of the Norfolk County District Attorney's Office.
attempting to indict Reed and Aiden Kearney, a.k.a. Turtle Boy, on new witness intimidation charges. As we previously reported, a grand jury blocked the indictment.
They returned no bill, meaning there was no evidence whatsoever that Karen Reed, or Aiden Kearney had committed any crimes. So I'm bewildered why those phones weren't turned back over immediately.
You've never received a rationale or response saying, hey, we're keeping them for this reason or another?
Well, I think the civil lawyers may have some interest in it. The civil lawyers can fight in another case if they want phones or cars or anything.
John O'Keefe's family has filed a wrongful death suit against Reed. That's the civil case attorney Buzang is referring to. I asked DA Michael Morrissey's office why the items haven't been returned to Reed, if there are any protocols for doing that. The response, no comment. I'm investigative reporter Ted Daniel for your local station, Boston 25 News.
No comment.
What is that?
No comment. That reminds me of the no comment I got out of. I don't think they have a new press person. Well, now the press person's been there for not quite a year, but they hired a new press person who is experienced in the media. He gets a 6-figure salary. And I reached out to them when Vanity Fair printed the article, and within the article said none of the top trial attorneys at the Norfolk County District Attorney's Office would try the case. They refused to try the case. And I scratched my head at that. I called the Norfolk County District Attorney's Office. I actually spoke to a person in the press office who said nothing other than referred me to a press release that had nothing to do with this case. So I faxed them. I wrote them a letter and faxed them, and I got a confirmation that the Norfolk County District Attorney had received the fax. I got crickets too. Nope, nothing. Not a return call, not a return fax, nothing. Not even a little, we can't. I didn't even get it. We can't comment. So that tells me that was true. So the Norfolk County District Attorney's Office is pretty good at not getting back to people, and they're pretty good at losing cases too. So now the breaking news on this item. This is on the docket. The motion to get the car and the phones was filed on the 28th. On the 30th, see what I've highlighted this is the actual court docket. Commonwealth motion for permission to return physical evidence to the defendant. So apparently the Commonwealth, the district attorney's office, is asking for a court order for permission to return physical evidence to the defendant, but that document is not on the docket. See how all of the other items on the docket have, images that you can click, and I clicked on the motion up here, the defendant's motion for return of property. I clicked on the image and downloaded it, and that's what we just read. I also clicked on a couple of other documents, which we're going to look at in a minute, but this document is not on the docket. And I discovered this on the 30th, and I thought certainly by now they will post that document, but it's not there. So I don't know.
So the Commonwealth it seems like the Commonwealth doesn't have authority to return it if they're asking for permission, which I don't understand that.
Well, I guess they're trying to cross their T's and dot their I's. Maybe they feel that if they gave it back, one of two things come to mind. Either they're thinking they've got to cross their T's and dot their I's. What if the civil attorneys want to get it and send out a subpoena, and oops, the district attorney has given it back without authority. So that's the first thought that comes to mind. The second thought that comes to mind, do you have the dun 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 sound effect ready? The second thought that comes to mind is, what condition might that Lexus be in by now? I mean, they pulled the chips. They probably damaged the chips. It doesn't have a taillight, but that would be the least of their problems. That would be the least of their problems, because you can go to a dealer. It's not going to be cheap, but you can go to a dealer, get a new taillight, I'm certain, for that make model of Lexus, and replace it. That's going to cost money. But the electronics, these days, the electronics of any vehicle, especially a high-end vehicle like a Lexus, are the guts of the vehicle. So is the thing even drivable without a great deal of work that was put into it? That was my first thought. And before I get to my second thought, did the people that went through the car have any thought to preserving those parts that they weren't examining it? I mean, did they rip stuff out? Did they lean on it and bend up the front, bend up the body? Did they, God knows if it was in a garage, if animals got into it. I mean, I don't know. You'd like to think, dear viewers and commenters, and tell me I'm wrong as you do every episode. You'd like to think that it was in a secure location, but mice and stuff get into my garage, and once the mice chewed through some cables and the car wouldn't start and it had to be towed. So who knows? Anyhow, so that's my you don't have those problems in California, Yoli?
No mice. No. Earthquakes. We had one yesterday, wasn't it? 4.4.
Wow.
It felt stronger than 4.4. And then the day before we had a tsunami warning, which was a nothing burger, but I got this huge alarm on my phone, a tsunami warning. It was the worst alarm I've ever heard ever.
That could have been horrible, but I was questioning that myself. I mean, the earthquake was a huge earthquake. It was a huge earthquake, but it was off the coast of Russia, across the Pacific Ocean. So I was wondering how big it could be by the time it got all the way to your neighborhood.
So Newport Beach would be the beach that is closest to me, which I'm a higher up, so I think I would be okay. But if there was a wave coming from Huntington Beach, which is further north, it could come from that way. I was just thinking in my head, it was just, I didn't get much sleep that night because, it's so alarming to think.
Did they get anything at all on those beaches? Anything?
Not really, no.
So my second thought was this, over and above the condition of the vehicle, which would certainly be a reason for stalling, I wonder if instead of tearing the thing apart, they put it back together and one of the hacks in Massachusetts is driving it around. I mean, could.
The civil case, and I think it was stayed, but they're still going to pursue that, the family?
Yes.
And do you know if her car insurance company is handling that for her?
I don't think that they did, no, because it involves alcohol. I think they wiggled out of it, if I remember correctly. I'll get an answer to you next time I talk to you, but I think they wiggled out to it. Insurance companies, the first time you ever put in a claim, and I've worked for insurance defense as a summer intern, the first thing that they do is they look for exclusions and reasons to decline coverage. And so I think that's what happened, but I'll have to check that and get back to you. But what I was going to say is, first of all, what condition is the vehicle in? Second of all, if some hack in Massachusetts is driving it around. Now, dear commenters, you're going to say, oh, well, how could they register the car? The Massachusetts registry has been caught with its pants down handing out phony registrations. Well, how could they do that? Well, we actually had a governor in Massachusetts that was handing out phony Social Security numbers. So if you're not from Massachusetts, you should take that into mind and wonder if one of the hacks in Massachusetts or somebody in the DA's office. I mean, I don't know. I'm speculating, but that's my second possibility as to why the district attorney's office is stalling for time. So
yeah, because if it wasn't entered into evidence, that means the court doesn't have jurisdiction over it, right?
Well, if it's being held by the Massachusetts State Police, and if it was seized with a lawful warrant, I think they're just covering themselves. You've heard of CYA, and I think that's all it is. So now the next thing in the case that's going on is this: Mr. Brennan's motion to withdraw. See that? WITDRAW. Undersigned counsel moved to withdraw from the above docketed matter. Undersigned counsel's position as special prosecutor has concluded. Respectfully submitted, Hank Brennan. Dated July 30th of 2025. And so
I remember one of his motions had a special prosector instead of prosecutor.
Yeah, and another one said Mr. Brennan, Breenan, and under Rule 11, we are all deemed to have read these documents before they're filed. I remember back in the old days, we actually had paper and we actually signed them. But so, why am I bringing this up? Is this even an issue? I guess yes and no. I used to have a friend who would always say yes and no, and I hated it. But anyhow, Mr. Brennan's contract is up. He performed the services of a special prosecutor. He was hired in September of 2024. He submitted a bill in the total amount of $566,000. I know different people have bandied about different numbers, but the final bill was in fact $566,000. We went over the bill in detail in a previous episode, including his billing for time on Christmas Day, New Year's Eve, and New Year's Day for the total of $566,000. But in any event, his contract is done. But I don't think that's the real reason he got out of it. I think he wants out of the case because there's no prejudice. And in order to withdraw, tell me if it's the same in California. I would imagine it is, but I don't know. You can't just simply withdraw and leave your client prejudiced. You have to make sure that they have other counsel. And in this case, the Commonwealth does have other counsel. They have Mr. Lally and Attorney McLaughlin.
Yeah.
So there's really no prejudice. He should have stated that in this motion.
Well, yeah, I mean, this is just kind of like just to withdraw. There's nothing to it.
Yeah, but you really
there's nothing cited, no, code section cited, or I don't know. It's strange. In California, we have a whole form that we have to fill out, so it's different.
And so I think that the reason he wanted to get out is because he saw a bunch of issues like the one we just mentioned. There are other issues that can come up post-trial, but the first issue is, why are they withholding giving back her Lexus and her telephone? And he wants no part of it. He's done. He tried the case. He wants to get out. He doesn't want to be on the hook for that, because if he's still in the case, now he's got to start responding. He's got to start saying, well, all right, here's my response to that motion. And he's saying, I want out. I want no part of that. I want to move on with my practice, in Park Square in Boston and do what I have to do. So that's the reason I think he's getting out. In addition to the fact that his contract is done. His contract was to try the case. He tried the case. Bada bing, bada boom. I guess he wants to get out.
Wow.
So next on my list of stuff that's going on in the case is that Victoria George, remember her? Victoria George was the juror in the first case who also just happened to be, she was a juror in the first Karen Reed trial. And then she signed on because she's an attorney. She signed on to represent Karen Reed. And so she was there. She really didn't play much of a role. I think she played kind of a role in the jury selection of this case. But now comes Victoria George, respectfully moves this honorable court for leave to withdraw as counsel in the above captioned matter. And this is a motion to withdraw. She states the reasons.
Yeah. Hank Brennan didn't have a declaration or affidavit attached to his motion?
I didn't see one. Counsel's representation of the defendant was limited to her trial. The defendant's trial concluded on June 18th, 2025, and judgment has been entered. Counsel notified the defendant in writing on June 23rd, 2025, that she no longer represents the defendant and is not involved with her probation proceedings. Now, this is key right here, number 4. Withdrawal will not prejudice the defendant who is currently represented by other counsel. In connection with this withdrawal, counsel also respectfully moves to withdraw as pro hoc vice sponsor for any out-of-state attorneys. And so, she goes on. She lists 5 reasons and then respectfully submitted. There she is. There she is. So she is out of the case, or she's respectfully requesting permission to get out of the case. And that's how you do a motion like that. And there's no prejudice because there are other attorneys. So now let me go back. You asked me a question. Didn't Mr. Brennan file an affidavit or anything like that. So I'm going back to the document, to the docket, and I want to answer your question because I want to be fair to everybody. Even though people hate it when I say I want to be fair to Mr. Brennan, I want to be fair to him and bring up the docket sheet. Okay, we're looking at the docket sheet now. And we see that on the 28th, defendant's motion for return of property, defendant's motion for relief. We're going to look at that next. Yeah, there's no affidavit or anything. See this right below the highlighted portion, yeah. 7/30/2025, Henry B. Brennan Esquire's motion to withdraw. So I just wanted to be fair. So I went back into the docket, and yeah, there's nothing. He did not file, as you asked, an affidavit or a declaration or anything else. He just, I want out. I want out. Bye. So,
oh my God.
In any event, yeah,
I'll allow it.
You shouldn't have any part of my late week shenanigans. But the next thing that is kind of, not really just kind of, but the next thing that's big here is the motion to disclose the sidebars. Do you remember all the sidebars in that trial? Well, now the defendant, Karen Reed, and her attorneys have said, we want that stuff. We want it, and we'd like to take a look at it. Here's that motion. What do you think will happen with this?
I guess it should be released. The purpose of the sidebar is for the jury not to hear what is going on, but there is no jury anymore. The jury has been released.
Right.
So I'm thinking that it should be released, and I'm thinking that they want it for a reason. And that being that a lot of things happened with Mr. Jackson and his sidebar comments. But is this for all the first trial and the second trial, or?
Let's take a look. This is the defendant Karen Reed's motion for relief from the April 14th, 2024 order to impound sidebar conferences. So April 4th, the answer to your question is this does go all the way back to the beginning of the first trial, because the first trial, I remember it well, started April 14th of 2024. So Karen Reed comes before the court, respectfully moves to release the transcripts of sidebar conferences that occurred prior to and during the two trials in this matter from the court's April 14th, 2024 order. So that answers that question. As grounds for this motion, Ms. Reed states that good cause no longer exists for impoundment. And this gives some background. Rule 7 of the Uniform Rules of Impoundment provides that a judge evaluating a motion to impound documents may enter an order of impoundment only if good cause to withhold the documents from the public is shown. To determine whether good cause is shown, a judge must balance the rights of the parties based on the particular facts of each case. And they cite a case which stands for the proposition that the decision to grant access to court documents is best left to the sound discretion of the trial court to be exercised in light of the relevant facts and circumstances of the particular case. So we go down. Once entered, an impoundment order remains an interlocutory order subject to the continued existence of good cause. And they cite rules and a 2004 case. Unlike other orders and judgments, an impoundment order carries no continuing presumption of validity to sustain it against a proper challenge subsequently brought. A party seeking the release of impounded court records does not bear the burden of demonstrating either that there has been a material change in circumstances or that whatever good cause may once have justified their impoundment no longer exists. The burden of demonstrating the existence of good cause always remains with the party urging their continued impoundment. So I found this interesting that Karen Reed, the defendant, who is moving to release the documents with regard to the sidebars, I found it interesting that She's the moving party here, asking for the documents to be released. She does not have the burden to show why they should be released. In fact, the burden of demonstrating the existence that good cause exists to keep them silent would be with the party urging their continued impoundment. So maybe this is one of the reasons that Mr. Brennan wanted out, because if Mr. Lally or anybody at the Norfolk County District Attorney's office wants to continue to keep them secret, they're the ones that have the burden. I thought that was interesting from a legal point of view.
It is interesting. So it's like she files the motion, and then it's like a motion. When California, it's a motion to show cause for, or to get an order to show cause why they shouldn't be released. And the person who is not wanting to release them has the burden, even though you file the motion. So yeah, that is an interesting point. But I recall that that there was a sidebar with Mr. Jackson that got kind of sticky in the first trial, and then it came back up in the second trial with ARCA, the experts,
yes,
and whether they paid or didn't pay.
Yes.
And that could possibly cause Mr. Jackson some problems with the state bar, and perhaps that's why they want the sidebars, or for other reasons. But that's one reason that comes to my mind.
Yes, good point. I think that Alan Jackson's point would be, I obviously can't speak for the man. I've never talked to the man. I don't know him. I can only surmise that he would want those released to clear his name if people think, as maybe you alluded to, I don't know, that, he did something wrong. A lot of observers, including me, felt that the judge kind of twisted the timeline, and that Mr. Jackson did in fact give an appropriate timeline. He was accused of not being truthful with the court in the second trial, when the judge said she had grave concerns, and he may well want to release these documents to indicate in detail what the contents of those sidebars were. So that's a good point that you raise. I think it's an interesting point that they filed the motion. They have no burden. The Commonwealth, and Hank Brennan turned tail and got the heck out of the case before he had to deal with this, because he wants nothing to do with it. He got his 566, and
but the court needs to order him. It needs to provide an order. I mean, in Massachusetts, can an attorney just file a motion to withdraw and then just withdraw? No. Or does the court have to issue an order?
You've got to get leave of court, in my experience. Get
leave of court, right? You have to notify the client, and you have to have a hearing.
Yes, all those things. Yes, yes.
So he may not get relieved. So if he didn't put the reasons why he wants to be relieved, he may not. But I don't know.
Gray area, because he didn't plead it. He didn't file a declaration or an affidavit or just set forth the reasons that grounds exist. He didn't do it in his motion. He just had one sentence, "I want out." So the question is he going to need to file something additional? Because again, there are two other attorneys of record, or more possibly. The Norfolk County District Attorney's Office has attorneys of record representing them. So I don't know. That's a good point that you raise. So I guess we really don't have to read too much further into this, because we've covered it, because good cause no longer exists for the order of the impoundment to be continued with respect to the sidebar conferences, and because access to those materials is required for trial preparation, the impounded materials should be released at a minimum to the parties. Interesting. After a verdict is returned, the potential prejudice to the parties will be greatly lessened, and that all parts of the record, except any that the court specifically finds subject to further impoundment for good cause, would then be made available to the public. And I'm only thinking, there were two minors, John O'Keefe's niece and nephew, testified in the trial, and we weren't allowed to see that. The cameras were turned off because they're minors. So I can imagine to continue to protect the minors, perhaps anything at sidebar that had to do with those two would be protected and redacted. And the other thing that comes to mind is personally identifiable information. Certainly the names of jurors, if the names and addresses of witnesses were mentioned. Those are the only things that come to my mind as to what might be redacted. I don't know. Do you have any thoughts about that?
No, I think you're right. I mean, I think with regard to the minors, yes. But anything else I think should be released.
Yeah, so now let's see. We have the motion to return the Lexus. We had Hank's withdrawal. I had the docket sheet. So that's pretty much it for this week. But I found it interesting that much was made, as well it should be, about the fact that the defense filed their motion to get the Lexus and the telephones back. And the Commonwealth did file its motion for permission to return physical evidence to the defendant. And they filed that 2 days after Karen Reed's motion, but it's not available on the docket. I mean, what's that all about?
Maybe there's a technical difficulty. I don't know. I don't know if it takes time to load those on the docket, but it seems like everything else after that was loaded. So I don't know.
Yeah, that's what I was just going to say. And I think, unfortunately, I took that down. But yeah, that was loaded. That was filed on July 30th. And then 2 other documents were filed on the 31st. And they are in the system. And as it's been explained to me, we can file stuff. Well, we're expected. Attorneys are expected to file stuff electronically. Gone are the days of running. Did you ever run to a courthouse and get one of those big quickie date stamps on a document?
Oh, I remember those days.
That's long gone. Yeah, I remember when I was in law school and I clerked for 2 different firms, one in Boston and one in the Boston burbs, as the low legal assistant on the totem pole. I remember running into the courts and, there's no parking in the Cambridge court anywhere. So you find parking on a hot day, and then you go down to the clerk's office and kaboom, this big loud, those days are long gone. Or mailing, the mail, I'm sorry, friends that I have in the post office, the mail can't always be relied upon. So, so now we're all expected to do everything electronically. And so my point is that, my understanding of the way the system works in the Massachusetts state courts is that you file the thing electronically, but a human hand needs to actually put it up on the docket. And the reason for that is not because they're old-fashioned. The reason is there might need to be redactions. There are certain matters, especially domestic relations type documents need redactions. There might need to be, the court might want to just take a look at it and make sure that it is what it is, and the attorney didn't accidentally, file his lunch order.
Right.
Stuff like that has happened, actually. Like that has actually happened.
A lot of crazy things happen when the courts here never really got it together. There's still problems that you can file something and then it doesn't show up on the docket, and then it says it's filed, but nobody at the court knows it.
Well, my point is that, my point is that a human hand, once you file it, once I file a document in Superior Court, it appears in the docket, but a human hand has to actually touch it and review it and make sure it goes out. And I've got to say, in Massachusetts and New Hampshire, the 2 states that I work in, they do a pretty good job. At first, the transition was just awful, but they got it together. They're pretty good. So enough about that. So Victoria George has withdrawn. Karen Reed has filed to get her Lexus back. We don't know what's going to happen with that. Hank Brennan is out. And that's pretty much it for this episode, except we need to read our comments. You want to take the odd ones or the even ones?
I'll take the odd ones this time. Okay. So at not FBI wrote 8:03. I guess that's a timestamp.
Yeah.
How or who was able to approve an hourly rate of $250 an hour for Hank Brennan if the rate was set at $65 an hour? Question mark. How would it be legal to determine that the workload for the prosecutor is any more significant than the workload of a defense attorney? It seems awfully biased to say that an attorney who represents the Commonwealth should be paid more than an attorney who represents the public. It seems fitting considering how much power and control the Commonwealth folks believe they hold over the people they claim to represent and protect.
I need to explain this one to you because this is a local issue that actually had a lot of interest on YouTube, which shocked me. It really shocked me. What this relates to is, yes, we all know that Hank Brennan signed on as special prosecutor at a rate of $250 an hour. The public defenders in Massachusetts, the public defenders notified the courts back in May they were going on strike because they're only getting $65 an hour. And the average, I said in this episode that I have the icon for in the lower left-hand corner, the average in Massachusetts is more like 300, 318, 350, 400. Those are the averages for different types of legal services. So they said $65 an hour is not enough. We're going to go on strike. And the Supreme Judicial Court said, listen, if defendants are being held for a period of time and they don't have attorneys, you're going to have to set them free. And so one day towards the end of July in the Boston Municipal Court, the judge, acting at the direction of the SJC order, dismissed over 100 criminal cases, and defendants that were being held were set free.
Yeah.
So, $65 an hour is nothing. And some people said, oh, well, $65 an hour times 40, that's all. No, because $65 an hour doesn't go into the attorney's pocket. The attorney has overhead. I actually spoke to somebody that administers these things yesterday. And that person pointed out to me correctly that $65 an hour does not go into the attorney's pocket. We all have overhead. I pay 3 rents. We have a light bill. We have a telephone bill. We have to have fax machines, scanners, computers. I don't even know how many computers I have. We have office overhead. And for $65 an hour, that's not what's going into the attorney's pocket. And so that's the context of that. I just wanted to explain.
Yeah.
To you.
Interesting.
I don't know. Does California have some kind of an oversight system? Like in Mass, we call it the CPCS, the Council for Public Counsel Services.
No, well, I'm not familiar with it because I do civil work.
Right.
But I do know that, a couple of years ago, or maybe a year and a half ago, one of the counties here dismissed over 2,000 cases because they had no courtrooms. So because the civil cases were backed up because of COVID, and they just couldn't get it together, and there was crime galore, and people were getting arrested and they were being held, and then when they didn't waive their right to a speedy trial, so when their trial date came, there was no courtroom available, so they had to dismiss it.
Wow.
It was really bad.
That's worse than our little Massachusetts. Yeah. Wow. Okay. Number 4, Gina M 3939. If the state didn't overcharge Karen Reed for something she didn't do, not once, but twice, they'd have extra money to pay these lawyers a normal salary. I live in Massachusetts, and after hearing all this, the burden is going to come down on us. They're going to raise our taxes and squeeze out any extra money they can from us, even more than they already have. It's such BS. So many of us are struggling financially as it is. I would agree.
Yep. Okay, this is from Kirk 7143. No wonder there isn't money when the likes of Gallagher are paid over $350,000 a year to use leaf blowers and solo cups. Dever, I think that's how her name is said.
Kelly Dever. Don't call me Dever. Kelly Dever.
Dever had her pay increased 3-fold, and she's a rookie who lies. Then we get to all the pensions being paid to the suddenly retired cops who are involved in nefarious activities, who secure their nest eggs in good name and not have to answer for the things they have done.
Yeah, remember Lieutenant Gallagher? He was the highest ranking Canton police officer at the scene the day of John O'Keefe being found in the snow. And he was the highest ranking cop in Canton. And he's the one that got the leaf blower and used the solo cups, even though they could have gone back to the police department, which wasn't that far away, about a mile and a half away, and gotten correct blood collection containers. And yeah, he $350,000 a year. I think most of our commenters would be happy with that.
Yeah.
Judy Hawkins, 6. Great to hear Bederow's harsh words for Lally. We have plenty of competent people in the mass justice system, but someone like him gives a lot of good people a bad name. And there must be other less prominent people who are equally deficient, letting him get away with this kind of thing.
Okay, Tracy talks a lot. Okay, also, I think if the Commonwealth of Massachusetts is bringing in a special prosecutor, that prosecutor should be paid the same rate as they pay the public defenders.
That'll never happen.
It's interesting.
I mean, it is interesting. As a matter of, I don't know, global equity, sure. But I wouldn't hold my breath. I see what you're saying, Tracy. I see what you're saying, Tracy. In the scale of things, I don't think we'll see that happen. So that's the end of this episode. Thank you for joining us. Let us know down below what your thoughts and comments are. Do you want us to do, Yoli and I talked about doing an episode on the Brian Walsh case. Let us know if you want to hear more about the Brian Walsh case. There's a lot happening. The trial is coming up in October. Is the Brian Walsh case slam dunk, or are there issues? Let us know down below. And so, Yoli, you have any closing thoughts for us this week?
No, other than the Karen Reed saga still continues to some extent.
Oh, boy. So we always ask people at the end of every episode to, if they've watched all the way through to the end of the episode, to leave an emoji. What emoji should we ask for this week? Do you have any ideas?
Cars.
A car. That's a good one, yeah. A car. A Lexus. Any car. I think they have SUVs. I think they do have SUVs. But yeah, leave us a car. Leave us an emoji. Yoli, thank you so much for joining me for this episode. Dear viewers and commenters, please subscribe and like below. We're up to 26,000. We're going for 100,000. I know it's unrealistic, but that's just the way I am. Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.